Hi everyone and welcome back to Flow Migration Law. I'm Jason, your principal migration lawyer. If you're watching this, you've likely found your person and you're ready to build a life together in Australia. That's the exciting part. The challenging part is the admin mountain standing between you and that future, the Subclass 820 partner visa. As we move further into 2026, I need to be upfront with you. The way the department assesses these applications has tightened. The days of throwing in a marriage certificate, a handful of photos, and hoping for the best are truly over. Today, I'm going to give you a 2026 roadmap. We'll look at the realities of eligibility, the 4 pillars of evidence, and why consistency is now far more important than just the volume of documents. Before we dive in, a quick disclaimer. The information in this video is for general information only and is not intended as legal advice. Immigration laws change regularly and every relationship is different. You should always seek advice tailored to your specific circumstances. A common confusion is why there are 2 visas. Think of it as a 2-act play. When you lodge onshore, you're applying for both at once. Act 1 is the Subclass 820, the temporary bridge that lets you leave work and use Medicare here. Act 2 is the Subclass 801, permanent residency. Remember that this is assessed over time. You must remain eligible and in a genuine relationship right through to the final permanent decision, which is usually 2 years after you first applied. Now, before you start gathering photos, we must confirm the legal foundation. In my experience, many refusals happen not because the love isn't real, but because the application didn't meet a basic legal hurdle. Generally speaking, to apply onshore, you need to hold a substantive visa like a visitor or student visa without a no further stay condition. If your visa has expired or you're on a bridging visa, you fall into a much more complex category involving Schedule 3 criteria, which requires very careful strategic planning. Also, ensure your sponsor is eligible. In 2026, we expect the department is going to be heavily focused on sponsor character checks. Past issues involving violence or family harm can prevent sponsorship regardless of how genuine relationship may be. Next, how do we define your relationship? You don't need to be married, but de facto relationships are examined very closely. The golden rule here is usually the 12-month rule. To apply as de facto partner, you generally need to show you've been in a genuine de facto relationship for at least 12 months immediately before applying. This doesn't just mean dating for a year. It means combining your lives emotionally, financially, and domestically under one roof. If you haven't hit that 12-month mark, registering your relationship with your state or territory government is a very practical strategy. It can waive that 12-month time requirement, and this is big, it does not replace the need for strong evidence across the 4 pillars. You still need to prove a shared life exists. This brings us to the core of your application, the 4 pillars of evidence. Please don't look at these just as a document checklist. In 2026, case officers will use these as 4 analytical lenses to see your story holds up. They are looking for patterns and internal consistency over time. First, the financial aspect. They aren't looking for a specific structure. They're asking, do these partners share financial responsibilities organically? If you open a joint account today and lodge tomorrow with no transaction history, that often attracts scrutiny. Second, the nature of the household. It's not just about sharing an address. It's about how you function domestically. If there are gaps in cohabitation, they need to be logically explained based on real-life work or family reasons. Third, social aspects. How is your relationship viewed by others? In 2026, public-facing information like social media is increasingly checked against your application narrative. If your statements say one thing, but your public life says another, that's a red flag. And fourth, the nature of commitment. Are your future plans mutual and realistic? The department doesn't assess these in isolation. A weakness in one might be okay if the overall picture is coherent. The danger zone is when the story doesn't align across these pillars. Finally, we need to talk about the practical reality of costs and timing. This visa is a significant financial commitment. Beyond the high government application fee, You must budget for mandatory health checks, police certificates from certain countries, and professional translations if needed. Regarding professional times, averages can be misleading. The reality on the ground is that decision-ready applications, ones that are front-loaded with police checks and medicals, and tell a consistent story, tend to move more smoothly. Incomplete applications get stuck in the request for more information pile, causing avoidable delays. Applying for an 820 partner visa in 2020 is less about ticking boxes and more about presenting a well-documented, consistent narrative of your life together. Having spent over 8 years dedicated specifically to Australian migration law, I've worked with couples navigating everything from straightforward applications to very complex situations involving visa refusals or character issues. Every relationship tells a different story, and your legal strategy needs to match it. If you want to ensure your application is built on a solid foundation, or you have complicated factors you're worried about, you're welcome to contact us at Flow Migration Law to discuss your situation. Thank you for watching, and all the best with your journey.